Can't see myself here. I don't know what's going on. I might have to go out and use another device. Okay, let me go out. I'll be back.
Okay, sir.
Ooh. Okay. Oh, lights. Good morning, folks.
Good morning, sir.
Good morning, sir. It's good to see you.
Yeah. Good to see everyone.
Hi, Matt.
Hi, Juliana. It's good to meet you.
Good to see you. Thank you so much for joining us.
It's our pleasure. It's a wonderful opportunity.
Thank you. Hi, Benjamin.
Hi, Juliana. Yeah,
It's good
thanks for the invitation. This is great.
Thank you. Thank you, Professor. Thank you for joining us.
Good morning or good afternoon over there. Yeah, it's morning here.
So, okay. Okay.
Hello, everyone. Can you all hear me? Hello, everyone.
I hear you.
Yes, we can hear you.
First, I would like to welcome you all, both the mentors and the mentees. My name is Adleke Okoyemi Christiana, a law student of Olabisi Onabanjo University, and I will be your moderator for today's session. Now, introducing the program. Sis, can you help me share it? About the program, JIIPCC Artificial Intelligence and Technology Mentorship and Internship program is a quarterly program for students, young professionals,
I don't know. I can't hear you clearly. Can you all hear her clearly?
No, I can't hear her actually. The thing is breaking.
across Africa.
Your network is bad. Maybe you have to log in.
Mentees are afforded
So,
Sorry, we apologize for the network issues. I guess that she's having bad
having bad
network.
network issue. Okay,
Yes.
so I will
So
just
I would like.
I'll continue
Okay, so Hussein
moderating.
wants to continue. He can just continue.
Until she comes back. So JIIPCC Mentorship and Internship Program, the objectives of the programs are to provide easy access, quality professional guidance, training and resource materials for students, young professionals, and enthusiasts across Africa and the globe. And one of the other objectives is to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders. And lastly, to transform mentees into mentors and leaders of the next generation. These are the objectives and about the program. So next, we'll be sharing the announcements for the week, which is, the first announcement for the week is that the registration for the next quarter of the JIIPCC Mentorship and Internship Program is currently ongoing. We have new courses and areas that we are mentoring on, which is patent drafting and health tech. If you are interested or you have a friend that is interested in any of the programs, please kindly register. Second announcement for today will be that the 30 minutes one-on-one mentorship program with any of the mentors that you are interested in having a one-on-one session with is currently ongoing. You can register with the link bit.ly/JIIPCPM. And finally, the last announcement for today will be the JIIPCC Mentorship and Internship Program, the Get Together Picnic by the end of the year, which is the 10th of December. The registration for the picnic is currently ongoing. We send the links to your WhatsApp groups and social media groups so you can register. If you are living in Abuja, if you are living in Lagos, we are holding the picnic in these two states in Nigeria. So I'll be reading the mentor's profile shortly. The first mentor today is Professor Samuel Samei Andrew. Professor Samuel Samei Andrew is a member of the faculty at the College of Law, Prince Mohammed bin Fahd University, Al Khobar, United of Saudi Arabia, the Kingdom of Saudi Arabia. He is also a US ambassador, distinguished scholar, and professor in intellectual property law. He holds an SJD degree from Suffolk University Law School, Boston, USA, and LLM in intellectual property law and policy from the University of Washington, Seattle, USA, and LLM in international law and jurisprudence, and an LLB Hons from the University of Uyo, Nigeria. A former managing partner at ZFC Law in Port Harcourt, Nigeria. He was also formerly professor of intellectual property law at the University of Gondar School of Law, Ethiopia. Thank you very much for joining us today, Mr. Professor Samuel. Sorry. That's the first mentor for today. I don't know, is Opeyemi with us now? Or should I continue? Okay, I think she's not with us yet, so I will continue. Second mentor for today is Mr. Benjamin Mark. Mr. Benjamin Mark is the patent storyteller TM. Many artificial intelligence company can generate complex technology that are confusing for others to understand. Benjamin assists AI companies in building their patent strategy that clearly tells the story of the invention to their stakeholders and to the patent office. Please contact Benjamin for the white paper on AI patents. Benjamin is a partner of Readout and Maybe LLP in the firm Toronto office. His practice is principally directed towards patent drafting and prosecution, with an emphasis on the field of AI, machine learning, blockchain, cryptocurrency, non-fungible token, NFTs, metaverse, and extended reality. technology, signal processing, biomedical, computer, and electricals. Benjamin is a graduate of the biomedical electrical engineering stream of the engineering science program at the University of Toronto. He previously worked as a research engineer at a Toronto area hospital where he was involved in the development of medical imaging device. Thank you very much for joining us today, Mr. Benjamin Mark. And our last mentor for today is Mr. Matt Norwood. Matt Norwood is a partner at Readouts and Maybe LLP in the firm Toronto office. His practice is directed towards drafting and prosecuting patent application, litigation, intellectual property disputes, and advising clients on IP licensing matters. He is licensed to practice as a barrister and solicitor in Ontario, as an attorney in New York, as a registered patent agent before the Canadian Intellectual Property Office, and as a registered patent attorney before the US Patent and Trademark Office. Matt provides legal advice and options to clients on intellectual property strategies and transactions, including patent and trademark filming, IP licensing and acquisition, policing and enforcing of IP rights, and IP due diligence and risk management. He has experience in a wide range of industries, including semiconductors and artificial intelligence, nuclear power, construction, cannabis, robotics, telecommunications, and medical device. Matt is a seasoned barrister with experience arguing IP cases with the Federal Court of Canada and Federal Court of Appeal and the Ontario Provincial Courts. He works closely with clients to understand their business and their technology, advising them on litigation strategies designed to protect and advance their specific business interests. Originally from Washington, D.C., Matt has also lived and worked in Boston, New York City, and Toronto outside of the office. He volunteers as a judge for the First Robotics League, an organization that cultivates passion for and excellence in the engineering discipline among high school students across Canada and US. Matt enjoys hiking, camping, and biking with his wife and two lovely young children. Thank you very much for joining us, Mr. Matt Norwood. So we advise all our mentees to put up their video because the meeting is being live streamed, and also edit your name session so for attendance purpose. We'll be calling on the first group that we'll be presenting. As we all know, our topic for today is role of AI in intellectual property.
Hello, can you hear me? Can anybody hear me?
Yes, sir.
Okay, and so I'll be.
Yeah. You.
All right, so I'll be taking the presentation on behalf of Group 1, and we'll be looking at the role of intellectual property and artificial intelligence. So I would love to start. Please, Bono, the next slide. Okay, so I would love to say that the art of creating is actually one of the significant parts of human existence. Through the creativity of man, we've been able to shape our world and have actually molded the way things have been done. And it will be very important to also know that artificial intelligence as part of human creation has actually shaping or is shaping, and we continue to shape the existence of man. And since there is this need for the protection of the creativity of man, there's kind of a nexus between the artificial intelligence and intellectual property. Of course, intellectual property refers to creation of the mind, such as inventions, literary and artistic works, and it could be in the forms of patent. That is the protection that comes from intellectual property. It could be in the form of patent, copyright, trademarks, industrial design, trade secrets, and geographical indications. And so these creations are actually it actually means that there is need to protect the creative work of man such that he got both the moral and the economic benefits from his creation. And of course, please, the next slide. Of course, we know that artificial intelligence itself, as was coined in 1956 at the Dartmouth Conference by John McCarthy, refers to the science and engineering of making intelligent machines. So these machines that could sense environment and act intelligently, which are the creation of man, ought to be protected. This is the next slide. So how has intellectual property been used to protect AI inventions? So just like I said, AI inventions are actually the creation of the mind, and they are part of this intangible assets that needs protections. So as AI currently is experiencing a paradigm shift from theory to commercial applications, and key players in the AI sphere acquiring large portfolios of AI and of intellectual property rights. So as we earlier noted, intellectual property is a category of property that includes those intangible creations of the human intellect. There are many types of intellectual property which are recognized based on different jurisdictions, but we know of the ones that I actually mentioned earlier, that is copyright, patents, trademarks, and trade secrets, and the rest of them have been actually used by inventors over time to grant protections to their inventions. Statistically, there is, according to the World Intellectual Property Organization, there are nearly about 340,000 patent families that are related to artificial intelligence alone. Between this period of 1960 and early 2018. So I'll just, apart from patents and copyrights, copyrights actually protects software codes that constitute the building blocks of AI programs. In fact, as a matter of requirements and principles of law, source codes must have to be reduced into writing. So AI algorithms, especially those that are not easy to reverse engineer or decompile, can be protected as trade secrets, and trade mark protects the names of robots. Please, the next slide. So we will now try to analyze some of these intellectual properties that have been deployed by AI inventions. So for example, patent, which is the exclusive rights that preclude others from exploiting the inventions of the creator or the inventor. So one could actually have to file for his products to be listed around patent, and for one's inventions to acquire the rights of these patent rights, it has to has about 3 criteria. It has to pass through 3 criteria. So it has to be novel. It should be something that is unavailable globally of the time it was filed, and it also has to be something that has inventive step, and there should be a technical character. Please, the next slide. Copyright. Copyright is a type of intellectual property that gives its owner the exclusive right to copy, distribute, adapt, display, and perform a creative work, usually for a limited time. There's actually a challenge that because of algorithms can be expressed as computer programs and part of software, there are two possible avenues which they might attract copyright protection. So as work or as computer programs. It's actually a challenge whether AI inventions can also, sorry, can you hear me?
Yes, we can.
I hear you.
Okay, so there's actually a challenge if AI products can actually form parts of copyrights, can come under the protection of copyrights. That is in the Berlin Convention, but subsequently the TRIPS Convention has actually confirmed that computer programs can fall within the ambit of the protection of copyright. Please, the next slide. So trade secrets. These are type of intellectual property that includes formulas, practices, processes, and designs or compilations of information that have inherent economic value because they are not generally known. So they're just a secret. So it includes any business information that has commercial value derived from its secrecy. So AI and algorithms generally are anonymity. So patents, copyright, and trade secrets are viable means of protecting artificial intelligence. The right approach is dependent on many factors, including the type of AI to be protected, the likely lifespan of the technology, and the value of the AI and its importance to the business. Please, the next slide. So what type of IP protection is mostly utilized by inventors in the artificial intelligence industry and why? So we find out in the research that of the current IP rights that affect AI, patent is enjoying a special attention as nations, public institutions, research organizations, companies, and universities all over the globe boost an individual ownership of thousands of patents. For instance, the IBM, which has largest portfolio of AI patents with about 8,290 patent applications, followed by Microsoft. I think Google Deep have an AlphaGo and so moving AI systems and algorithms under the auspices of patent law not only helps circumvent the barriers to algorithmic and transparency via public patent applications and compulsory licensing options, but also reflects the true value of the invention itself as technical and novel, rather than simply maxing the system behind corporate and confidential rules. Next slide. Examples of inventors that have utilized IP and how they profited from protecting their artificial intelligence. South Africa's Patent Office, its Companies and Intellectual Property Commission has granted the patent and recognizing Dabus as an inventor, giving to the inventor the rights to exclude others from making, using, or selling their patents, their inventions, and can transact more efficiently in the market inventions. So that is an example of an AI invention that has been patented. So this next slide. Next slide, please, if you can hear me. Okay, conclusions. So we found out that as conclusion and recommendations, the AI has a profound impact on the world, and there is need for the creation of additional layers of AP laws to accommodate emerging innovations. So there's need to fine-tune the law to fit in the current circumstances and even the future ones that are coming out in the intellectual property field, since the laws are not really all encompassing with this creation. So there's needs to have this law to fine-tune them to meet up with the present situation. And also Just like according to Franz Gehry, the Director General of WIPO, from a purely economic perspective, if we set aside other items of the IP system, such as just reward and moral rights, there's no reason why we shouldn't use IP to reward AI-generated invention operation. So basically, IP laws are there to ensure that both the moral and the economic rewards of one's invention are secured from exploitation. So AI and IP law develop hand in hand. So there's needs to develop AI and IP laws to work in hand to ensure that these creations are protected and the inventors actually get the right reward from this. So that is that.
Hello, everyone. Can we hear me?
Yes, we can hear you.
Yes. That was an excellent presentation from Solomon. Now, moving on, we have Group 2 for their presentation. If you're available, please unmute your mic. You can unmute your mic. Group 2. Where is the speaker for Group 2, please? Can you hear me?
Yes, ma'am. Hi.
You can start.
Yeah. Good afternoon, everyone. My name is Ekundayo Ifedayo, and I'll be presenting on behalf of Group 2. The topic for this course is ownership of intellectual property by artificial intelligence. Before I probe further, I ask this question: that do you think artificial intelligence can own intellectual property? Well, we'll find out. The World Health Organization defines intellectual property rights as rights that are given to persons over the creation of their minds. However, they are exclusive rights that are given to inventors or authors, and they enjoy these rights over the use of their creation for a certain period of their time. Please, can you hear me?
Yes, you can.
Yes.
Yes.
All right. There has, however, please, next slide, please. There has been debates on the ability of artificial intelligence to be created independently and apart from human inventions. In the year 2016 now, for instance, there was an AI program that co-authored a novel titled The Day a Computer Writes a Novel. And this novel was shortlisted into a writing contest for the Oshi Shinichi Literary Award. Inventions now. Inventions are protected by a body of law called patent. We have others like copyright and the rest of that. But over time, there has been changes in how inventorship is viewed, and it raises the question as to whether a machine could be an inventor. To answer this question, let me take you through the various decisions of authorities regarding DABUS. DABUS means device for the autonomous bootstrapping of unified sentence. Please, can you take us to slide 5? Yes, DABUS is an artificial intelligence system that was trained to mimic the aspects of human brain function. And it was created by Dr. Steven Teller. Dr. Teller filed a number of patent applications and was regarded as a patentee, while his own creation, that is the DABUS, was listed as an inventor. Please, the next slide. Dr. Taylor submitted his patent applications to US, UK, and South Africa. And in Australia, in Australia, the Deputy Commissioner of Patents in Australia after several considerations, concluded that by naming Dabus as the inventor, the application did not comply with registration number 3.22AA. Please, the next slide. The next slide after this, please. The European Patent Office, that is the EPO, similarly held that the European Patent Convention, that is the EPC, requires that a natural person will be an inventor and that an AI machine cannot assign patent rights to the applicant. In South Africa, Taylor's application was accepted because of the country's depository system. Please, the next slide. In the US, only the works that are created by human beings are recognized and registered, while those that are created by machines are not. And this is because the US Copyright Office will not grant a copyright registration unless the author is a human being. Please, the next slide. In Nigeria, like other intellectual property laws, the Nigerian Patent and Designs Act recognizes an inventor in whom patent right to be invented to be a person. Now, from the above, it has been deduced that most jurisdictions rule out the possibility of artificial intelligence being an inventor, but there is the need to adequately protect inventions devised by AI. Thank you.
Thank you very much. I think we lost Christiana again. So we'll be calling on our mentors now to give us their contribution and comments. So we'll call on Professor Samuel. Please, you can unmute yourself.
Okay, thank you so much. Those were excellent presentation. I'm so proud of y'all. It shows that we are about to birth a new generation of experts of IP in Nigeria and in Africa. So this is all what I live for, especially in my home country, Nigeria. I like to see IP take its rightful place. So thank you, Julian, for what you are doing. And thank you for all other mentors who are here. So I'm going to touch, make a few comments on, maybe add one or two things. On the first paper, the first presentation, the role of IP and AI. So you did a good job of drawing the intersection of IP and AI. But I mean, why are we so particular about AI? Why is this all the literature, the fight now in courts to make AI legally distinct, or making AI something, in my opinion, that shouldn't be too much of a problem? We should be thinking about human creativity. Why? Well, because I've been doing a lot of research on this area, and I've come in, this is my initial, I would say preliminary opinion, like I said in one of the conferences I spoke, that it's all about economics. And we have seen the evolution of the digital era creativity and innovations. I mean, from 1996, when WIPO, the WIPO copyright treaty came into being, and the lobbies, and especially the developed economies, lobbied to change the jurisprudence of copyright to catch up with technology. We have seen a lot of progress has been made by recognizing the place of technology in the creative spaces and in the innovative spaces. We've seen the changes in the laws. Even Nigeria, because I was part of this new law, which has luckily been passed by the National Assembly, is awaiting the president's assent, the copyright laws of Nigeria. We have recognized the place of technology in creativity, in ownership of creativity, in protection of creativity. But my concern really now is, where is Africa? Where is the developing economy in all this race to turn artificial intelligence? That's what I want you to pay attention to. You know, we saw how the copyright term limits was moved from 50 to 70 through the lobby of Disney in the Sonny Bono case. We saw how we've been struggling for more than 30 years now in all the international forums to make folklore and our traditional knowledge and cultural expressions to be recognized legally. It's taken 30 years. Now we've seen the speed, how suddenly AI, like you know about the case Davos, is the United States Court of Appeal for the Federal Circuit recently denied Dr. Teller, you know, my good friend Ryan Habot is in the forefront of pushing this movement of making AI an legal inventor or legal creator or legal author. So I would want us to think, where is the position of the African creator? How are we? Because it's going to happen whether we like it or not, because, you know, it's all about economics. Like I said, it's all about politics now. They're going to change it. The law as it is right now does not give AI the legal right to be an inventor. All the courts, all the major courts, like the ownership, the group 2 referred to. So I'm going to be going back and forth between group 1 and 2 because your topics are almost similar. So all the courts recently, if you don't have the case, I have it. I will send it to Julian. The recent decision of the Court of Appeal for the Federal Circuit that denied Dr. Teller that Davos cannot be an inventor, because both patent law and copyright law specifically says that only persons. I listened to the argument in the Court of Appeal or the Federal Circuit. The council, they were trying to expand the definition of person beyond both the literary meaning, the common sense meaning, and the legal meaning. Well, we don't know yet how it's going to be done, but I feel that it's going to be done because, like they always do, the interest groups, probably they will change the law. One of the courts would agree that AI should be like a human being without considering all the difficulties in terms of tort laws, in terms of ownership rights, how you're going to equate a machine with a person, because person means person. So as we continue in this discussion, because it's an evolving discussion of the role of intellectual property in AI, let us also remember that already the law has recognized, based on, for instance, the digital Millennium Copyright Act that came from the WCT, the WIPO Copyright Treaty, and even Nigeria, we've also, the current law has recognized places of technology like technical protection measures. For instance, what is a technical protection measures? There are softwares, there are programs that, you know, creators embed in the computer systems or in the digital systems to, you know, control how you distribute or how you enjoy or how you assess their works. You know, we've heard about geolocks. Those are, you know, you cannot watch Netflix or some platform in certain countries. Those are all forms of AI, really. Because like someone said, one of the presenters put it very well, these are all softwares. These are all machine readable programs that it's part of the AI system. So copyright already is benefiting. Same thing with patent. They're benefiting from these technologies to protect both patents or both creativity, especially on the digital platform. So there is this symbiosis. There's this marriage, which has been recognized even before the current movement of the AI advocates. It's already, we already know that softwares, which are foundations, which are, you know, the organic structures that controls most of the AI systems, are protected both as literary works on copyright, and also software can also be protected by patents. So there is enough protection there. But now going back to the ownership issue. So why all this move when the law, I think from 1886, when we had Bern's Convention and when we had the Paris Convention, it's already been defined. Persons have already been defined that you can only be a person to be an author. I'm going through the new laws in Nigeria, even the old law, the copyright law. We're talking about persons. There's nowhere, we are not even talking of artificial persons. We are talking of persons. And there's nowhere that laws, both in America, the US, but in UK, or Australia, and Germany, even South Africa, that I think the first judge kind of granted ownership to AI. I don't really think it's going to stand the test of time on appeal. I don't know the current state of the case because I've been traveling. But anyway, we know of the major courts already have denied AI ownership of IP. So what if it happens? As emerging scholars, how, in terms of the North-South economic development, how do we catch up when AI, because I have not seen much in terms of even innovation, patents filing. I've not seen much from the South, the global South, which includes Nigeria. So how are you as emerging scholars? What is going to be your role to be at the forefront? Because like I said, this is a movement and it's an economic movement. And we've all seen this trend before. We've seen this dance before. You know, from one way or the other, they're going to lobby, they're going to make this happen. So, but we have to be at the forefront, at the front, so that we'll be able to be the advisors and the stabilizers of our innovators in the global South, in Nigeria. You should start looking at how to protect your clients, how to start teaching, expanding your curriculum, and be a disciple on either we're going to change our laws or we're going to make sure that we are not disadvantaged like we were when they moved the term limit to 70. And it took us a while to catch up to the 70 In fact, some African countries are still at 50, like Ethiopia. Some countries, like my current country, Saudi Arabia, they're still at 50. So there is a recognition that we have the relationship between AI and IP, but there's also that although now AI does not own the IP in both patents and copyright and any other IP, but it might happen. Thank you. That's my short take for now, so that I can allow other mentors to talk. I appreciate you all. Thank you so much.
Thank you very much, Professor Samuel. We'll be calling on the next mentor quickly, which is Mr. Matt Norwood. Please, you have 8 minutes to comment and give some contributions.
Thank you, Hussein. Thank you for that, Dr. Andrews. It's a tough act to follow, but I first wanted to say that I also was really very impressed by both presentations when I read them and then hearing them again today. One thing that I really appreciated was that each of the presentations had a slightly different focus. And I think broadly speaking, and I think Dr. Andrews' comments touched on this, I think this question about how concepts in intellectual property can apply within the field of AI can be looked at through two quite distinct ways that are interrelated, but really implicate sort of distinct sets of questions. And I think there is the first half, and the first presentation was primarily focused on this, which is the question of sort of the reality on the ground of AI as an industry and as a technological change that is, that we already see some of the economic impacts of it. And what are the economic impacts going to be, and how, and who is going to benefit, let's say, from IP ownership of AI-based technologies. And this is, as I think Dr. Andrews touched on, a hugely important set of questions about not just law, but then the economic effects and the geopolitical effects. There are, of course, some countries that are net IP exporters and many countries that are net IP importers in terms of revenue flows. And, I think there are really interesting questions about the way the international legal system deals with forms of IP like copyright, where essentially copyright, while it's territorial, of course, you mostly are able to secure copyright protection internationally without too much effort, as opposed to patents, which are strictly territorial. And in an age when various technologies can be located anywhere, on a data center located half a world away, there is a question about how patent systems can best protect the interests of the citizens of their own countries, and how they can foster economic development and technological development. And I think that these are vastly complex questions that AI directly implicates. Where are you developing your AI? Where are you running it? Who ultimately will benefit, and how can different countries, certainly Canada finds itself in this position. Nigeria, of course, is in this position where there are certain superpowers, the United States, China, who are leading the pack, but there's lots of room for innovation coming from outside. And how do you, how can countries, hope to secure some of the benefits for themselves? I think this is a critical time in the development of artificial intelligence as a sort of industrial reality. So there's all those really interesting questions about the intersections of law and economics. And this was the primary focus of the second presentation, although the first one also touched on it toward the end, is this sort of deep philosophical question about creativity and invention and the nature of what AI as kind of a mirror held up to humanity to say, well, what is it that a person is doing when they create, when they invent, when, this question of agency and personhood and creativity, and to what extent could it apply to an AI? Maybe not an AI that currently exists, maybe yes, maybe no. I have to say that before these set of presentations, I spend my time in that first world of protecting AI technologies on a practical level on behalf of clients. And the second question about, could an AI be an author or an inventor? I was a bit of a skeptic. I thought, well, the Davos thing seems like a bit of a publicity stunt. Is this real, or is this just another software tool? I appreciate the complexities of AI, but at the end of the day, it's software, and there are lots of software you can use to help you create things. AI just seems like a slightly more sophisticated tool. And I think I would have said that confidently up until a year ago. And I think that these presentations really opened my eyes to the fact that, especially with the tools we've seen recently, language models like GPT-3, image creation models like the DALL-E model that OpenAI released recently, to me, it really, I think it's a real question now. I think there are software tools that can be set loose on their own with very little input to create what appear to be creative works, what anyone would imagine to be a creative work if they saw it produced by a human. And I think, I think these philosophical issues have to be grappled with. Who has rights? Who should have rights? If a corporation owns an AI technology that creates works that are protected by copyright, should they own that? Do they own those copyrighted works? And what does that mean in relation to the first set of questions about economics? Is it that the big players in AI now will also own all of the content created by those AIs? There's some very serious questions to be asked here. And I think, as Dr. Andrews said, this is an evolving conversation, and these are hugely fundamental questions that I think we've only really begun to talk about. And it's happening in real time. Every 6 months, there's a new revolutionary announcement in this field. And so it's just really gratifying to see people grappling with these questions. I mean, I really, reading these presentations, I was converted. I had been skeptical and dismissive about some of these things, and now I think these are actually pressing questions that need to be addressed, and I love to see people talking about them. So congratulations to both teams, and thank you very much.
Thank you very much, Mr. Matt Norwood, for that contribution. And we'll be calling on the next mentor, which is Mr. Benjamin Mark. You can give us your presentation, your comments now.
Thanks, Hussein. Hope everyone can hear me. Yeah, two tough acts to follow. Just this entire thing. I always view most of these issues from more of a practical or from a practitioner standpoint. So it is good to see both the student researcher standpoint and the academic, and sort of how I guess the non-lawyer may look at these topics, because we're a little pigeonholed. We see it from the court's point of views or from daily practice. So both Matt Norwood and I are practitioners. We see a lot of patents, copyright not as much, just because generally it's pretty quick filing process. But we do see things like open source issues, and that does have things to do with ownership and the rights to do things. So I just made some notes. Again, good presentations. The first presentation, we'll just say, it was about AI as the subject matter of IP. That was really good. Some maybe a bit of history lesson for patenting in the United States, for example, since a lot of us follow the United States. Maybe a bit of history lesson. So in the early 1980s, well, let's start at the beginning. The beginning of the patent system was industrial processes, right? We have machines, we have chemistry, we have agriculture, and then we had something that's allowed to be patented, and we call that a process or a method. Okay, but in the early 80s, late 70s, we had these things called computers show up, and that sort of, we're going to have the same debate now, but it was the debate in the early 80s, right? That was computers, and the question was, is software patentable? And at the time, we had this funny thing called the computer with transistors, ones and zeros. And the US did say, actually, yeah, we put it on a computer, everything under the sun is patentable, all these things, as long as we programmed it into a computer, that's what we call a method or an algorithm or a process. And that's fine. So from a patent point of view, we were filing patents all the time. They had, as long as you created the computer, you said a computer that does this or a machine that does this, the patent offices were pretty open, and they didn't really care as long as the actual subject matter was new and inventive or non-obvious. So that was the good times until about the 2000s, when people, probably rightly so, said, wait a minute, why are we just putting ideas, laws of nature, abstract theorems, scientific facts, and then if someone just puts it on a computer, we're just giving them patents. So there was actually some debate. Patents started getting invalidated. So that was sort of the mid 2000s. So now we're in more of a balanced era. The first presentation did sort of have a good test that's sort of universally accepted, but maybe a little intentionally vague about how technical do you need to be to get your patent. And some of those things, the United States does have a test, and they really say, it can't just be an abstract idea and just put it on a computer. It can't just be a law of nature here. But a lot of these things do become more difficult. For example, you might have like a psychotherapy machine, right? It might diagnose you or do what a therapist does to make you feel better about some trauma, or if you're suicidal, or a lot of these things. Well, are these what humans are doing, or is this what the computer is doing? So a lot of that is being wrestled at the patent office and the court. Generally, it's hard to say what is patentable. It's more about saying what is not patentable, and the only thing that we can probably safely say at this point is the test that I said, that you can't just merely take an idea and put it on a computer and say apply it on a computer. That we can probably safely say the most. Everything else is pretty difficult. Well, there's some exceptions that are pretty clear as well, like tax crime, patents on avoiding tax and things like that. There's some actual specific stuff, but other than those, we're in the world that of some vagary, but they're trying to bring some balance, and a lot of this is going to be about balance. I don't want to go through the whole patent test of how to get a software patent, but those are some of the concepts that came up. It's good for people to look up the tests. The leading case is called Alice in the United States, and it's just a simple 2-part test, and there's some nice flow charts that you can look up. But it kind of gives you the whole picture that it's actually not so free and clear that an AI could be the subject matter of a patent, which was the first presentation. So moving on to software, again, some great examples. Just going back to the fundamental again. So the WIPO and basically the courts have basically recognized that, okay, again, back in the day, if you were an artist, you would paint a picture. If you were a musician, you would sing a song, or if you were like a movie maker, you would write a script, right? So that was copyright, original intent. But again, around the 80s or a bit earlier, people said, I am writing something. I'm not writing a story. I'm not writing a book, but I'm writing code. And they said, okay, you are creating something. That's what we call a work. So work is actually a specific legal definition. So of course you're protected from people copying your work, but the question is, what is a work and when do you get your work? And is AI a work, right? So people wrote the code. That's what we call source code. The courts have and the law has recognized that source code's good. You go compile it in your compiler. we call that object code or compiled code that turns into ones and zeros and makes the computer do something. That is also protected for the same reason that your literary code is protected, right? So now we're in the AI world, and so what happens when your code starts creating things? DALL-E was a great example. That's just the creation of images, and the real question is whether that that is the subject of IP, the subject of copyright law. It seems to be. Again, we all take our visual tests and we look at this nice looking new picture and say, yeah, that looks like that should be covered by IP, from a personal consumer point of view. And the courts, if that is 100% artificially generated art, might be a nice fractal or an actual image of something, is that IP? I mean, it just seems to naturally follow to me. So I guess one more sort of copyright issue that might come up is it's sort of who owns it. Again, talking about the first presentation, we'll get to the second one later, is, for example, if I'm training my neural network on public images from Google Images, or maybe a proprietary set of images for a client, or I was able to obtain it somewhere, or some paid images like Getty images, and I train my own neural network, the question is who owns it? Or another example, which comes up a lot, is in the health field. I'm training my neural network on patient data, right? So who owns it? Is the patient? Is this a breach of privacy? Whereas at the end of the day, what you're going to get is that your neural network with a set of weights, correct? Right? That's the neural network. So having nodes and weights, is that really a breach of patient data? I mean, obviously, I usually protect the people trying to innovate, and in my opinion, that's not. We're just talking about weights, and matrices and multiplications. So to me, we're not really talking about the actual breach of the patient data, but other people may defer, especially health privacy advocates. But the point is, is this neural network copyrightable? And then who's going to own it? Especially if it's the owner of the source data or the person who actually created the neural network to then train it, whether it's to create images or to predict patient health and things like that. So that was a little longer than I expected. Hopefully, I'm not. Yeah, so I'm running out here, but so let's jump quickly to the second presentation. Again, really good. I'm just going to jump to, I guess, the real issue here. So yeah, can AI be an inventor or an author? That's a maybe. So maybe one food for thought is the point is really certainty and legal rights, right? So the point of Davis was the original inventor, I believe, or his corporation was the actual owner of the IP at the end of the day. So sure, he might name his computer, but at the end of the day, it was he himself that was the owner. So we get into property law problems where usually the first author or the first inventor is the owner. So if that's a computer, what does that mean, right? Is the owner of that computer the owner, or whatnot? Or if the computer just was running by itself and nobody owned it, then we have a legal right that can't be transferred because you can't ask the computer where it wants to transfer it. So property law, usually we say a person has to own it. A person can be a human being, it can be a company, or it can be a government organization, or other legal things like trusts. So these things are, they have property rights. That's what we call a legal person. So if there's no legal person and the first owner of the computer, well, it's really hard to give them all these rights, especially the right to transfer and the right to monetize and all those things. So the last final thought is maybe in terms of transferring rights, maybe there are exceptions or carve-outs that we may be able to use. Maybe you can look up smart contracts, and they're therefore some property rights are built in. That's a whole nother topic, blockchain contract. But maybe that would solve a lot of things that you can be the inventor, but who owns it, right? Yeah, so those are my thoughts. Hopefully that provided you some insight from a practitioner's point of view, give you a bit of history lesson. But no, I thought these were all great. I actually learned a lot as well, and yeah, I was able to see some balance on some of these insights. But I think we're all pro innovation, and we all want to settle these issues for the future. But this is great. Thank you very much.
Thank you very much, Mr. Benjamin, for your nice contribution. We really learned a lot from it. So we'll be moving straight to the question and answer. So we have 3 questions. We'll be asking each of our mentors 1 question each. So the first question is for Professor Samuel, which is if AI is protected by IP law, how would AI be able to stop intellectual property infringements? Professor, do you get the question or should I repeat?
Repeat the question.
Okay, the question is this: if artificial intelligence is protected by intellectual property law, how would artificial intelligence be able to stop intellectual property infringements?
Well, yeah, like I said already, let's use the template of the current laws, because I don't think there is a dispute as to whether artificial intelligence legally can protect IP. We've settled that dispute, I think, a long time ago. So we have laws already that's been tailored, meaning I'm going to use the word loosely now. When I say technology, I'm talking about AI. We've settled that problem, that fear that through when US added the Digital Millennium Copyright Act into the copyright laws, and other countries have done similar things by following the WCT. So, for example, we have lots of technology, lots of programs now. I gave you an example of a geolog. We have DRMs, digital rights management tools. We have a lot of embedded technology that we use to protect the delivery or the distribution of copyrighted works, mostly on the digital platforms. So if you, for instance, circumvent, we are talking about the anti-circumvention laws. If you break in or circumvent a technical protection measure that has been embedded in a digital platform, maybe to stop you from, for instance, breaking the password or the software for you to watch Netflix free, you have to pay. There's a system before you come in there to enjoy the movies on Netflix. I'm just using Netflix as an example. If you decide, because you are smart, we know you have a lot of smart people these days, and you now build a software to circumvent or clone the original software so that you can now sell it to people, and making money at the downside, which is piracy and all that stuff. So the laws are very clear now. I mean, it's both criminally. Most of the countries, their custom department are focusing on that area now. US, the Nigerian custom, Ethiopian custom, Saudi Arabia custom, they are both using 2 tools now, both the civil methods and the criminal methods to go against this infringement. So yeah, it's already there. But I think the problem we are having, the disagreement we are having, is the ownership issue of AI owning IP. But it's already there. The new laws in Nigeria, by the time it comes out, you will see it's already been recognized that technology, it's part of the jurisprudence now of protecting IP. I hope I've been able to answer that.
Thank you very much, Professor Samuel. So the next is the picture time. So we advise for our mentees to put on their video and take a screenshot of our meeting. If your video is off, you can put up your video, take a screenshot of our mentors. We want to see all your beautiful faces. Post on your social media and write a thing or two about what you've learned today. Thank you very much. Okay. Thank you very much, Mentees, for that. So moving to the next question, which is for Mr. Matt Norwood. The question is, in the event that AI is shrouded with intellectual property rights, who will be responsible for accessing patents? The AI, the owner, or the creator? Those are the three parties that are asked. If any of them will be, which of them will be responsible for accessing patents? Do you understand the question, or should we again?
No, I think accessing the patents in the sense of, let me pull up, this is, okay, yes, I see. Right, okay, so right, this is an example of the kind of difficulty that would be raised by the concept of extending inventorship to an AI software algorithm. That in the law as it exists, at least one person has to be designated as the inventor of a patented invention, which means that this is a person who mentally conceived of the idea behind the invention. And so if the conclusion of a court were that the idea was not conceived by a human, but was somehow conceived of within the operation of this algorithm, then you would have a software algorithm that's the inventor, at which point we do come into this. I mean, the law is currently not equipped to handle this situation. Inventors are always humans, which means they're legal persons, and they can sign agreements. They can be deposed in a court proceeding. You can't really do any of those things if you're a software algorithm. And so all of these notions about consent, about entering into contracts to assign your rights, can a software algorithm enter into a contract? Does it have capacity? Does it have standing? I mean, I think as the law stands now, the answer to all of these is no. And so, you would have to, if a legal regime decided that it wanted to recognize AI algorithms as inventors, there would have to be some framework put in place for presumably a legal person standing in as a representative of the algorithm, I suppose, is one way you could do it. You could say that if the algorithm is being controlled by a person, or by, let's say, a number of persons in a corporation, that maybe one of those people or that corporation could be the sort of, hold a sort of power of attorney on behalf of the algorithm. There is a version of this in some countries where the inventor is almost, as far as the legal rights are concerned, they are sometimes largely cut out of the loop of the chain of title of the patent rights. So if an inventor, for instance, is an engineer at a company and they have an employment agreement that obliges them to assign all their inventions to the company, in some jurisdictions, in many jurisdictions, the company itself can directly apply for a patent on the invention, and they can identify the inventor, but with the understanding that the inventor's rights have flowed essentially directly to the company. So that's the beginnings of a framework where I suppose you could have companies or individuals who control an AI applying for patents, naming the AI as an inventor, and essentially being responsible for all of the things that require capacity, things that require consent and require legal personhood. I think it gets trickier when, 10 years into the life of the patent, you sue someone for infringement and they want to investigate who the actual inventor is, and they say, well, I want to depose the inventor, and the inventor is running on a server somewhere. So I think there are lots of interesting questions there, and I think that legal framework doesn't exist yet. But I could see those various ways of approaching that question of how the rights are assigned or how they flow through the AI to another legal entity.
Thank you very much, Mr. Matt. So the last question is for Mr. Benjamin. So Mr. Benjamin, the question is this: if AI can invent new innovative concepts, should credit be given to the creator or the machine? So that's the question. It's simple.
Yeah, I think that's kind of what we're talking about today. I think the credit is what we would do in the last scenario that Matthew spoke about, which is often the patents that I file, there's a bunch of inventors named, but then there's also an owner of the patent who's also named. And the inventors got the credit, but they have no legal rights. And I think that's probably where we're all leaning towards, that just the machine just wants to get some credit. It can't sell it. It can't, have the royalty stream. It just wanted credit. And then the legal rights go to like a traditional person, which is a human being or a corporation. So it's the same scenario with copyright. Just do we give it some credit, or do we give the programmer of the machine for credit? The legal system, like it doesn't, obviously, no one thought of that scenario because the legal system was built on this innovation, and the first innovator is the first owner. And then you can transfer rights, or there might be a pre-existing legal right that said that right was automatically transferred. So this notion of recognition is sort of a social concept, right? We just want to give credit where credit's due, even though legally, right, we're kind of stripping those rights away or saying they were already transferred away. Or for example, the owner of the algorithm or the owner of the computer is really the first owner, but we gave some recognition. So, I mean, I always try to go back to fundamentals, which is, property law. And property law, one way of saying it is like, so let's say if you own a tree, an apple tree. So what does property law give you? You get the use and you get the fruit from the tree. So, you can sit under the tree, it gives you shade, but and hopefully I don't butcher this analogy, but yeah, if the apples fall off and it plants another tree, in theory you own that new apple tree, right? So hopefully we find an analogy here that the AI machine is not only itself, but it's creating new things, new trees. Hopefully that analogy works. But a lot of us work on first principles. So either you have to look at the law and you look at the first principles, or you'd have to change the law, or else the law won't fit. So that's sort of my I think so these are all good questions. But recognition and legal right may have to be separated, and it may have to be like an explicit exception written in the law. So hopefully that was some good insight, and people have a bit of takeaway from this.
Yes, we do. So thank you very much, Mr. Benjamin, and thank you very much, all our mentors. We are so happy to have you guys with us today. So I'll be giving it to Ms. Juliana to close the program and give us some closing remarks.
Thank you, everyone, for attending today. We've had a very intelligent and brain thinking session, and I think that this is a very good start. A very big thank you to Professor Samuel. Thank you so much for bringing the academic and intellectual side to this discussion, and for making us to think about what Africa stands to gain and how we can position ourselves in this new revolution that is coming. And also I want to thank Mr. Benjamin. Thank you so much for coming. And thank you, Mr. Matt, also for coming. We've actually learned a lot from the practitioner side, from the practical side, and how things are happening. And it's good that we're having this discussion. And so I would like to encourage everyone to follow the trend, follow the discussion, so that we can be abreast with the things that are happening, and as things come up, for us to understand this particular industry. So a very big thank you also to the mentees. Thank you so much for working together. Thank you for cooperating with one another to work on the presentations and the slides. We're so grateful. Thank you, thank you, thank you. And to the moderators for today, thank you also for the role that you played. We value what you've done, and we are excited about the things that you are doing with us. And so with that, we'll be coming to the end of the session for today. Please go back and listen to this session, because I'm sure that there are things that were said that you did not get. So go back, listen to it on YouTube so that you can understand this topic better. Also, read materials on this and follow the decisions that will be coming up in the nearest future. And with that, I want to say a very big thank you. Have an amazing weekend. Thank you, Professor. Thank you, Matt. Thank you, Benjamin. Thank you, Hussein. Thank you, all the mentees. And thank you, everyone. Thank you for staying. Have a lovely weekend. Bye.
Thank you, Juliana. Bye.
Thank you.
Thank you, everyone. Bye-bye. Have a good one.
Thank you.